The city of Edmonton, even after many warnings, still planned to desecrate a known sacred site as it was declared in 2014 using international law. They have refused to abide by the laws not only intentionally, but the Criminal Code of Canada, which still to this day protects Indigenous graves. We have tried numerous times to reach out the city concerning this area in particular, and it continually falls on deaf ears. One thing is for certain, that there is no time limit on a declaration, and this city can be charged for that crime. At no point in time were we ever consulted. A city or province cannot simply ignore a sacred site declaration. Recognized nation declarations trigger legal duties. Unrecognized or community declarations carry persuasive weight and must be considered in consultation. The government must either accommodate, mitigate, or legally justify development or risk injunctions, fines, or legal challenge. If a city or province ignores the Indigenous people who made the declaration and instead consults or relies on other Indigenous groups to approve disturbing a sacred site, it can lead to serious legal and cultural consequences. Authority comes from the rightful Indigenous community. Indigenous sacred sites and burial grounds are culturally and legally tied to the specific nation, First Nation, or community whose ancestors are buried there. Consent must come from the community that has cultural and spiritual authority over the site. Agreement from unrelated Indigenous individuals or groups cannot override the rights of the actual custodial community. If corporations or even government agencies continue disturbing Indigenous graves while deliberately leaving out the actual custodial community, the situation escalates significantly under Canadian law. This is considered deliberate disregard for Indigenous rights in the law, and the legal consequences can be severe. Duty to consult is site and community specific under Section 35 of the Constitution. The duty to consult falls on the specific Indigenous nation or community with rights and interests at that site. Consulting a different nation or unrelated community does not satisfy the legal duty. Misrepresentation or bypassing. Using other Indigenous consent to override the actual claimant nation is considered bad faith consultation. Courts have repeatedly held that consultation must involve the right holders, not substitutes. Haida Nation versus BC, Tsilhqot'in Nation versus BC. No statutory time limit exists. A declaration remains valid as long as cultural, historical, or spiritual ties exist. Government agencies must treat sacred site declarations as continuing legal and cultural claims, regardless of how long ago they were made. Our ancestors' bones have been scattered all around the Rossdale area, and the city has ignored that completely over the years. Biological decomposition of bones, organic components of bone, collagen and proteins, gradually decay, especially in soil with moisture, microbes, and acidity. Mineral components, mainly calcium phosphate, can last decades to centuries depending on soil conditions. Over time, bones may crumble into fragments or powder, but even small fragments are still considered human remains under the law. So far, they haven't listened even though they have said they consulted. Who? The only way this is going to be protected is to go to court, and personally, I have no idea how to go about doing that or have the funds to begin. This has been one of the setbacks. Funding.